All right, are we good to go? Recording? Okay. I would like to call to order a special meeting of council for the purpose of public hearing for Bylaw 23Z/22. Can I get a motion from council to move into special meeting of council? Councillor James has it. I'll call the question. All in favor? Thank you. I want to welcome everyone here tonight to the public hearing. The public hearing procedure guidelines have been provided in the agenda center of the MD's website. Today's public hearing is being held to hear proposed bylaw 23Z/22 for an amendment to section 26 of the land use bylaw 09-Z/18, adjusting setback requirements for the Rafter 6 Tourist and Recreation District in accordance with the Municipal Government Act, Chapter M-26, Revised Statutes of Alberta as amended. In public hearings, council must hear from any person, group of person, or persons representing them who claim to be affected by the proposed bylaw or resolution and who have complied with the procedures outlined by council, and may hear from any other person who wishes to make representations and whom council agrees to hear. There are a few housekeeping items that I would like to go over. Make sure to please state your name when you intend to speak. This aids the recording secretary. This meeting is being live streamed on YouTube, and a recording of this stream is available for future viewing. I will now ask for a motion to go into the public hearing from council. Councillor Smith has it. I'll call the question. All in favor? Thank you. The first step is for MD administration to introduce the proposed bylaw. Councillors will then be given the opportunity to ask administration questions. I will then call for the applicant or agent to speak, should there be one. Councillors will be given the opportunity to ask questions of the applicant. I will then call for those speaking in favor or in support of proposed bylaw 23-Z/22, followed by those speaking with a neutral position, and then those speaking in opposition to the proposed bylaw. Whether speaking in favor, neutral, or in opposition, persons speaking on their own behalf may speak for a maximum of 5 minutes, and persons speaking as a spokesperson for a group or petition may speak for a maximum of 10 minutes. Councillors will be given an opportunity to ask questions of each speaker after each presentation. The applicant will then be given the opportunity for rebuttal. At no time will disrespectful comments nor questioning of anyone's integrity be allowed. Council is then provided a last opportunity to ask relevant questions of administration on the proposed bylaw, and then the public hearing is closed. I will remind everyone that once the public hearing is closed, no further oral, written submissions will be received on proposed bylaw 23-Z/22. May we now please have the introduction of the proposed bylaw from MD administration.
Thank you, to the chair. I forgot to introduce myself earlier, so I thought I'll do that. My name is Rafter, one of the development officer, and then I would, just like we did earlier, I would be co-presenting this with the Director of Planning Services, Peter Charles. Thank you. So, this is the public hearing for the proposed land use bylaw. So this is the second part of the public hearing today, and it is the proposed land use amendment for Rafter 6 within the MD land use bylaw 09Z 2018. Just as following the requirements in the Municipal Government Act, notifications for the proposed bylaw 23Z22 were done in accordance with the requirements or provisions in the MGA. Information about the proposed amendment was advertised in the Rocky Mountain Outlook newspaper for 3 weeks, January 1926 and February 2nd, respectively. The notification was also mailed to the landowners within the district, and the agenda for the public hearing was uploaded to the website, to the MD website as well. Again, we have the chart on the screen showing hierarchy of plans, which we touched on earlier. And just as we mentioned previously, this chart is to provide information about some important plans and the hierarchy. The land use bylaw is a tool to implement statutory plans by the municipality, and it is meant to be a living document, which means needs to be reviewed from time to time to meet and address development concerns. On the screen is the Rafter 6 district map with some important information in different colors. In red shows the current land use bylaw 30-meter setbacks, and in purple, the representation of the proposed meter that we are proposing today or in the amendments. So that would be the 5-meter.
Through the chair. Through the chair. Okay. We'll spend a few minutes on this map to go over it in some detail. We'll complete our presentation, and then we'll press the back button a few times and come back to this map. So I will, for council, I'll go over this in some detail. White lines refer to the cadastral infrastructure. Those are property lines, leasehold lines, etc. of any kind. The green line that you see is the boundary of the Bow Valley Provincial Park. The Bow Valley Provincial Park includes this area completely surrounding the property in question, including this piece over here. The pinkish orange line is the western boundary of the Stoney Nakoda Reservation. So all this land over here is part of the reservation. This is the Kananaskis River flowing towards the top of the screen. The three properties in question are the two owned by Star 6 Ranch under the property owner name 1882870 Alberta Limited, including Title 151079397, which is this rectangle, and the same owner, Title 1510793970001, for this much larger rectangle. The Cowley Outfitters Limited property owns this parcel here, and the title number is 151035760. The red dashed line, which you will see 3 sets of them, one for each of the 3 properties, identifies the current 30-meter setback. With the proviso, as I understand, as I've described before, that under the area structure plan, the front yard setback is actually 40 meters, but under the 2018 bylaw, all setbacks are 30 meters, and that is represented by the red dashed line in all 3 properties. The pink line is the proposed amendment to 5 meters from 30 meters. So we are proposing to eliminate the red line and replace it with the pink dashed line. And this shows the increase in developable area on each of the 3 properties that would result from this amendment passing. I need to keep going though, because nothing in planning is that easy. You'll see cyan, I think that's a cyan color line that's dashed going down here. That is an approximate line. The land use bylaw has location-specific regulations and general regulations. Location-specific regulations would be something like the 30-meter setback for the RSTR district. The general regulations sit on top of that, and there's 2 general regulations of note. One is for slopes and one is for floodways. The floodway regulations in the current land use bylaw from 2018, which are verbatim the same as the floodway regulations in the 2012 municipal development plan, they're included twice, which is very unusual, basically to say that they're very, very important and very hard to change. Identifies a floodway as basically that area which is subject to regular flooding, usually with a freshet being usually associated with either the spring thaw or sometimes a rainstorm in the fall or something. So this is flood width. The precise definition is usually identified by a geomorphologist. I am not a professional geomorphologist, but I have 10 years of experience in geomorphology and mapping geomorphology. And based on the definition, I drew this cyan line to show approximately where it would fall. The cyan line takes precedence for development permits over and above the setback. So, for example, over in this area, which is close to the river and definitely within the floodway, there are fluvial rocks in this area. And it's not very high above the elevation of the river at low flow. And you can clearly see the areas regularly flooding based on the vegetation patterns. Although this is within the, this would be within the development zone by the setbacks, it is not, would not be permitted under the land use bylaw, and that will remain. The same sort of story would belong here, this little triangle, and this piece. We have another map to clarify that a bit more clearly down the road. Similar to the floodway are the slope setback requirements, which state that no structure may be within 15 meters, 20 meters of a slope of 20%? 20% or so. I'm going from memory, I might be off by a few numbers. And where there are steep slopes tend to also be where floodwaters don't go past. So again, the slope setback requirements, again, would trump the setback, the 5 or 30 meter setback. And we'll go over that in a little bit more detail in a coming slide. Now, we asked the cartographer, oh, there's one more line here, which is important, which is the 19-meter line. This orange line was established through a subdivision appeal that occurred in 2019-2020. The notice of decision, which was issued by the Municipal District of Bighorn on November 19th, 2020, point 4 subpoint A. It says a factory built dwelling for this parcel may be permitted a 25.75% variance or 10.24 meters to allow minimum front yard setback on the west side to a minimum of 29.26 meters. The planning staff who were involved in that decision do not have that corporate memory anymore, but our staff have been interpreting that as 19 meters setback relaxation. So the red line here is the 30-meter setback from the west side, and the SDAB decision allowed that to move to 19 meters. The reason for that is you'll note that once you include your setback from the floodway, you end up with a very narrow strip here, and there was inadequate space to provide an accommodation, or simply have a very extremely narrow accommodation. Once the SDAP, the Subdivision Appeal Board, makes a decision, it is no longer within the realm of the planning department to propose or make amendments. It's outside of our ability to enact any kind of relaxation. Specifically, thank you, Section 688, subsection 1, subsection A of the Municipal Government Act states, an appeal lies to the Court of Appeal on a question of law or jurisdiction with respect to a decision of the Subdivision and Development Appeal Board. So if once a Subdivision Appeal Board says the setback shall be X or Y, the Planning Department, that is what we will enforce. It is now outside of our jurisdiction for any kind of variance or relaxation. We asked our cartographer to measure the distances from current buildings to property lines to get a read of where these setbacks are playing out in real life. I'll go over a few examples here, but we did read into the file, and I have to be careful here, or we have to be careful here as the planning department, in that we have to make a recommendation to council based on best planning practice, not on case history. But we still did our homework. And in 2019-2020, the government of Alberta wrote a letter to the MD of Bighorn. I don't have the exact date off the top of my head, and we can provide the information later if you wish to see the document. That there were the Cowley, the owners of the Cowley Outfitters property here were using some of the space here out near or outside their property on government of Alberta land. Those issues did not exist when Halfset and I visited the property in October, November of 2022. One thing I forgot to mention is this long straight parallel line is technically a road right-of-way. When Alberta was settled, it was based on the quarter section with right-of-ways on its grid pattern, which worked great on the flats, but when we start getting into the foothills and the mountains, it does not work so well. And what we have here is a remnant. So this is technically a road right-of-way, but I can say with very high certainty that it will never ever hold a road, because it goes from the river to the river with a reserve and a mountain on the other side back to the river. It serves very little purpose. The access for this property is by using a portion of this right-of-way just here, and there's an easement agreement to allow vehicular traffic for this property to use this route through the Star 6 Ranch. That's how this property is accessed. Okay, sorry, that was a segue. I'll go back to the distances of buildings from the sideline. On this image is dated June 10th, 2022. So this is quite up to date, certainly as up to date as we're going to get without snow. So on the Cowley Rafters property, we have a number of hay structures, tents, these kinds of structures, one within 16 meters, one within 26 meters, one within 22 meters, and one within 1 meters. To our understanding, these are all permitted by the SDAB decision, so they are not an issue. But you'll see that the geographic factor of this, the geographic limit of the Kananaskis River floodplain is pushing development to the west side of the property. Over on the Star 6 Ranch, we have the primary barn is within 11 meters. This is a historic building. We have a lodge of down at 39 meters, which is fine. We have a couple of heritage cabins, one sitting on the lot line, one sitting within 11 meters of the lot line. And we have a number of yurts which were licensed, which were given a development permit in, I may be corrected, 2020 or 2021. And the closest one is approximately 5 meters from lot line. And our records indicate that we didn't open the development permit for the yurts, but we saw some of the maps, and on our air imagery, we see at least 2 of the yurts have been developed, because we can see the white dots for those 2, and our files indicate that 3 more have been permitted and may or may not be developed at this stage. But that's beside the point. Something else I was going to add. It can wait for another slide. We'll continue our presentation PowerPoint at this time.
On the screen are reasons for proposing the amendments, in addition to the explanation that Peter just went through. So the amendments, like we said, it's the current setback is 30 meters. We are proposing 5 meters. And for the rationales why we are proposing this, the first one is because the area is surrounded by parkland and leased crown land. Setback should reflect there are not and will not be close neighbors. The provision in the land use bylaw that allows for setback to 5 meters with rationale has been used frequently in the past, as recently as 2021. So for that precedence, we believe the proposed amendments is that would be one of the rationale why we're doing that. And the third one is the administration of the 30-meter setback has been a significant drain on staff time. Within the short time that I've been here, I can speak to that. Floodway setbacks will be unchanged, just as Peter showed us in the map. Similar land use district in Rockyville County applies 6-meter setbacks. So before bringing this proposed amendments and before coming to the public hearing, we did our due diligence to see to make sure that what we are proposing is comparable to what other municipalities have for a similar district. And for Rockyville County, it's 6 meters. On the screen are the proposed amendment for first to reduce the current setbacks from 30 meters, just like we have said. The table on the screen is just showing what we have in the current land use bylaw, which is 30 meters, and the proposed setback that we are asking or we are putting forward is the 5 meters.
Through the chair, administration would like to bring to the attention of council the precise wording of section 26.5.2 as it currently exists in the land use bylaw, and we'll read it verbatim. Notwithstanding the minimum front, rear, and side yard setbacks above, the Municipal Planning Commission shall have the ability to relax the minimum yard requirements as follows. A, to a minimum of 1.5 meters where there is a need to accommodate existing development or its expansion along a common boundary of 2 private titled properties which have the same owner, and only if appropriate documents are in place to ensure maintenance and similar provisions can be made across the property boundaries over the long term. And I read that one, although it's not on the screen. That is the provision which allows, remember I mentioned that there's a couple of properties that are very close to property line. This is the provision that was inserted for that.
Sorry,
B,
just to clarify while we're going, that's what exists right now?
yes,
That A, okay, thank you.
and B, which is on the screen behind me, to a minimum of 5 meters where there is an obvious advantage obtained from such relaxation in terms of recognizing topographic features or existing development, or at the discretion of the development authority where the architectural presentation of the development will be appreciably enhanced. 2 points I just want to make. At first reading, I'll back up. By reducing the setbacks from 30 meters to 5 meters, this 26.5.2B is more or less rendered moot because it allows the relaxation to 5 meters based on rationales given. At first reading, administration did not suggest that this be removed, and I'm anticipating at second reading that the report will ask council for a motion to change the proposed bylaw amendment to remove this 26.5.2B. Second point is, and I do have to be careful here, staff reviewed the history of this location and the subdivision appeal hearings, and we had to, for a land use bylaw, we need to provide best professional advice based on current circumstances, not based on case history. But at the same time, we had to be prepared to answer case history. We did not find a record of 26.5.2B having been triggered or used at any time in the past. So I bring that to your attention based on the topographic constraints of floodway and slope that I have discussed already. So I just say this 26.5.2B we could not find, and I'm not saying we read every document, but we did do a fairly thorough review. We did not find any history of this particular passage having been used on previous planning decisions. Thank you.
So the image we have on the screen, it's just to show us the change in developable area with the proposed 5 meter from the current 30 meters. So additional approximate non-floodable developable area created by changing setback for each of the three properties that Peter mentioned or referenced in the previous slide.
Through the chair. Just so this map, we can be certain the implications are clear to everyone. Our cartographer was asked, could you please calculate the increase of developable area per property based on the proposed setback change from 30 meters from lot line to 5 meters per lot line, excluding what we estimate as the floodway perimeter. The floodway perimeter, as I said, has not been confirmed by a geomorphologist. It's based on slope and topography. So these numbers may be off by a bit, but they're not off by a lot. For This property, the one owned by Rafter 6 Cowley family, the increase in developable area is shown in green, and we estimate it at 0.55 hectares increase in developable area. For this property, owned by Star 6 McTaggart family, we estimate the increase of developable area at 2.4 hectares. For this property, also owned by Star 6 McTaggart family, we estimate the increase in developable area at approximately 3.98, say 4 hectares.
What we have on the screen here is just to reiterate further what the administration is proposing. Is comparable with the provisions for recreational land use districts in other municipalities, just as we have mentioned earlier in our presentation. Thank you.
Thank you, through the chair. For comparative, key aspect of this Rafter 6 area is it is surrounded on 3 sides by a provincial park, which presumably is never going to be sold out or used for any kind of significant development, and on the east side by the Kananaskis River and a reservation. The purpose of setbacks, I'll back up. Planning touches on constitutional law in that in a democratic and free society, in theory at least, the involvement of government should be to the least amount necessary to ensure the orderly development of a free and prosperous society. I'm not quoting that exactly right. I'm not a politician, but the overall constitutional thrust is that laws and bylaws should serve a purpose and should be defensible on a logical and rational method. So some sort of logic. So for example, in agricultural areas, you'll often find 25 or 30 meter setback from lot line. The purpose for such a setback is actually usually based on fire. If a barn on one property catches fire, if it's 60 meters, so 30 plus 30 meters away from a different barn, chances are it's far enough away that the second barn won't catch fire. The other examples are too numerous to mention, but there's some reason for it. So when a property is surrounded by a non-development zone, whether it be an island, like surrounded by water, or surrounded by a park, as in this case, there needs to be a reason. You need to think, why are we ordering people to keep their development a certain distance away from the setback, and is that distance defensible? In this case, it's surrounded by parkland, and it's a recreational use that is guided by an area structure plan with clear architectural guidelines. And the owners have found frequent reason to suggest variances in one form or another for staff housing or hay bales or some sort of tent, or most recently yurts. And the Alberta Parks has not presented issues with that. Also for comparison, we looked at what's happening next door in Rocky View County, and there's 2 land use districts we looked at. One is called the Special District for Parks and Recreation. And that's basically districts for county parks, and there is no minimum setback. So the number would be 0. Now, those are typically owned by the county of Rocky View, so they would obviously have other guards in place where they put their gazebo or such. A closer district is Business Recreation Land Use District, which would be quite similar in use to the RSTR. It's focused on tourism uses in those kinds of purposes, and their setback is 6 meters. I will mention, to be completely thorough, that under the Business Recreation Land Use District, they have a 30 or 40 meter setback from county roads. We don't have a road in this case, but we do have that phantom right-of-way, which, as I've said, is extremely unlikely to ever be developed. But I want to be thorough because that is technically a road right-of-way. Thank you.
Thank you. That concludes our presentation. Thank you.
Thank you very much. Are there any questions from counselors for administration? Go ahead, Counselor Smith.
The race is on. I actually have two questions. Is there a provincial standard for setting municipal setbacks? Like the discrepancy between a 6 meter and a 5 meter, is there some sort of basis that we can grab for provincial standard that would help guide us?
Through the chair, no. There's best planning practice, and that would normally, for this something of this very particular type of application, the appropriate step would be to look at your neighboring municipalities and see what they've done.
Counselor Tusa?
I'm looking at the page with section 26.5.2. And I believe you said subsection A would allow, is there a relaxation to 1.5 meters?
Through the chair, yes, there is, but that applies to only two properties that are side by side, owned by the same owner without any other factors of note. So administration would not recommend removing or amending that that passage as it serves for a number of heritage cabins that exist on the Star 6 Ranch.
Okay. Yeah, I just needed some clarification. Thank you.
Counselor Alford, go ahead.
And in the original ASP that was done, did Rafter 6 Ranch have a part of that? Were they a part of the original ASP? Did they present it, or did the MD, how did that get done?
Through the chair, I don't know. We had the former, we have the owner of Rafter 6 Ranch make a presentation at the last public hearing where she mentioned that she was involved in this ASP, but this ASP was passed in 2006, and administration did not look into that deep into the file that we looked into the history of the development of this area structure plan.
And in that, just so I'm clear, so there was a 40-meter setback in that original one, and now it's, then it got changed to a 30-meter, or is proposed that the 40-meter gets taken out, and we go to a 30-meter. But I'm trying to wonder, like, that ASP, it's kind of, if Rafter 6 came up with the original ASP and owned that land, all three parcels, why are we now concerned about the setback that they proposed originally?
Through the chair, I have to be careful about guessing. Typically, area structure plans are a give and take between the MD and the developer. So they can be influenced heavily by the preferences and biases of the planner involved. I had a thought and it left my head as I was saying that. But your second part of the question was, if they owned it, why are we changing it? That's it. The reason for looking to change it is since 2010. I do know that a tremendous amount of staff time has been devoted to various aspects of the administration of this 30-meter setback. That doesn't seem to be lightening up. We have a large number of existing variances allowing entry into the 30 meters. We are not aware of as I described it, constitutional reason for the 30 meters. It might have had something to do with the date of the establishment of the park, because before did we have a date on the establishment of the park? Okay. If the park had not yet been established, 30 meters would certainly make more sense. Once you have a park, you can be reasonably certain there will not be development there. So that might be one reason, but I'm guessing at that stage. Where we are here now is the area surrounded by park. We have a lot of variances in place. We're continuing to deal with a large number of various factors that are using staff time. And the best practice at this time is in that 5-6 range when you know that there's not going to be any development on the other side of the property line.
So I'm trying to get caught up because I missed the first reading, but who brought this forward? What brought this to the MD's attention that we needed to change this? Did we just for the public, why are we all of a sudden diving into the setbacks in this one property? Or the 3 properties?
Through the chair, the MD received a development permit for a second mobile dwelling unit on the Cowley property, which is the property in the northeast, the smaller property in the northeast. The positioning of the unit was within the 90-meter setback that was shown on the map. We'll go back to that map. So we issued a stop work order. Halfsat and I arranged a site inspection. We went and we walked the site. We also received a complaint from the Star 6 Ranch, which included some drone photos from directly over the Cowley site. So we had double reason to investigate. We walked the property with permission of the landowners, and we were able to take a good look at it from a planning enforcement perspective. And the idea, it became noteworthy that the application of best practice would likely indicate that reducing the setbacks may be appropriate in this case. The concept was discussed at a pre-council meeting, and council advised to move forward with this. It passed first reading and is now at public hearing, where I'm very aware that there are some strong sentiments around the setback, which we're all here to listen to what people have to say. And as for the enforcement of the stop work order, we delayed doing that until this amendment had been either accepted or rejected, and then we could proceed accordingly.
So they applied for a second dwelling with a development permit, and then I don't understand the stop work order if there was a development permit applied for. Because you said earlier in the yurts got a variance, so did they get denied a variance on the second dwelling? Because I see one dwelling on here. Is there 2?
Through the chair, So, the development permit was to bring in a bigger factory-built dwelling to replace the one that was previously approved. And based on the information that we have on file and some conditions in the approved development permits at that particular time, we felt that the right decision was to refuse that development permit application.
The subdivision appeal board allows for only one dwelling unit on the property, and there were two. So the stop work order was basically, you've got to move one of them off and you've got to get it behind the 19-meter setback. Our understanding was that the Cowleys were amenable to doing so, but preferred to, I have to back up here. I'll make sure I have to check that my memory is correct. The development permit only allows one house. There were now 2 mobile homes, and they stated they were in the process of moving from their smaller, older one to their newer, bigger one. That takes a certain period of time. It is the winter time, and as I said, when we toured the property, it became apparent to administration that application of best practices would involve raising the question of reducing the setback requirements.
So is that dwelling that's there in the 19-meter SDAB setback? Because if they already have permission to have within that, I guess I don't understand why we're changing it. Like it doesn't appear that it's in there based on that map. So they got an SDAB approval. Does it fit within that setback right now as is? Either one of them?
Through the chair, it is possible to fit a single-family home with the 19-meter setback in place. Yes.
And it currently is in that? Is it in position?
As of our site visit in November, December, it was not. The old one was still there, and the new one was sort of straddling the 19-meter setback.
Okay, and the old one is compliant though?
Yes.
With the SDAB hearing?
Yes.
I'm gonna see if anybody else has some questions, just.
Sure, I'll come back to them.
Okay. Are there any other questions on this side? Go ahead, Councillor James.
Through the reef, what types of structures require development permits?
Through the chair, under the RSTR regulations in the 2018 land use bylaw. So I'll proviso that because some of the wording has changed in the last 25 years, and with the area structure plan still including the 1996 land use bylaw, those land uses have different words, but basically they mean the same thing. So with that proviso, under permitted uses, so permitted uses means that the owner can apply to the development officer, and the development officer can issue a development permit without going to the Municipal Planning Commission. There are 6: staff accommodation, extensive agriculture, single attached dwelling, farm structures, health and wellness center, and signs of 5 types. There's other development regulations limiting the number of development dwellings per parcel to 1. That is for single attached dwelling, and recreation uses limiting the use to 1.5 persons per acre on the site. Now under discretionary uses, and discretionary uses differ in that the development officer cannot issue a development permit without first going to the Municipal Planning Commission, meaning there has to be a meeting and they have to present their case with staff recommendation. The uses include accessory buildings and uses, resort accommodation, visitor accommodation, artisan shop, campground, commercial equestrian center, communication towers and facilities, country recreational center, country recreational lodge, cultural and entertainment facilities, energy generation systems, small licensed drinking establishment, places of religious assembly, public utilities and buildings, restaurant, shipping containers, signs, including roof or wall signs, store, convenience, a convenience store, store retail, so a convenience store or a retail store or a tourist information center.
With some of those buildings being temporary, like a shipping container, is there a time, like could that temporary structure be on there without a development permit for a set amount of time, but then removed without?
Through for the factory built dwelling that was approved, it was approved as a similar use, and with the intention that in the future there will be a permanent structure.
Councillor Smith, you said you had a question?
I do, and it's a fairly large one. We've heard of a lot of the positive impacts that this could have, and knowing that planning is very thorough, what are the negative impacts that this could have on the municipality and the landowners?
Through the chair, two come to mind. The first would be if forest clearing was involved or building into forested areas near the property line, 5 meters instead of 30 meters. If somehow the development started a forest fire of some kind, there'd be basically no time before it started spreading into the park. Versus 30 meters, there might be a few minutes. The second possible risk is basically if the Municipal Planning Commission was too liberal with a inappropriate development application. Say if someone wanted to build a big retail store right on the property line in the northwest corner of the Star 6 Ranch next to the yurts, it would be within eyeshot of the Rafter 6 Ranch, and that might cause some disconcert, some issues, but that would be a discretionary use having to, number one, get past the planning team and then having to get past the Municipal Planning Commission. But it creates 2 gates for checking instead of 3 gates. The permitted uses are pretty tight, so I don't foresee any issues with that. Hafsat, can you? No? Okay.
Councillor Over, did you have another question?
Would this increase the value of the land? And would there be tax implications to someone who's maybe trying to do a nonprofit? Does it make it a larger parcel to develop, and will that change their assessment?
Through the chair, it's pushing the limits of my expertise to answer that question, so I'll go with that proviso, and if still requested, we will make a request to the Finance Department. But taxes are based on 2 values. One is the value of the land, and one is the value of the improvements. The improvements obviously are not going to be unaffected by changing your developable area. Does the algorithm include for land value the developable area of the land or just the zoning? I do not know.
I just had another one in the Phantom Road right away. Is it being used? You said it's being used as a road in part of it. So is it being used as a road or is it not being used as a road?
Through the chair, the portion of the Phantom I suppose I shouldn't use the word phantom in a professional presentation, but the right-of-way on the west side of the Cowley Ranch is being used effectively as a driveway. And to my understanding, that is with permission of the landowner, who is the government of Alberta.
Not a public roadway, it's a private driveway?
It's technically a public right-of-way, but it's only being used by one landowner, and the only way you can get to that isolated strip of road is by easement through the Star 6 Ranch, which strictly limits the access to traffic that's associated with Rafter 6.
Unless Star 6 wanted to use it. If they developed and wanted to use it for access down to the river, could it become a road?
Through the chair, to do so, they would have to get a separate right-of-way from the province of Alberta to cut through a portion of the Bow.
No, I understand that, but
Mhm.
you said there's no access, but can it not be accessed from Star 6?
I
Yeah.
would suggest you just point on the map, maybe.
What I'm saying is I think it could become potentially public from Star 6 north to the river. Like, I understand I don't have access right now to go drive, or you, but Star 6 would have access to potentially a roadway. I mean, if this isn't I'm just trying to figure out, we say that it's a phantom roadway at this point, but potentially it could be a roadway for two property stakeholders.
Through the chair, I'm not familiar enough with the right-of-way regulations for Government of Alberta road right-of-ways to answer that question fully. I would need to call them, because they have about 6 or 8 different types of right-of-way usage policy, and I would have to look into that in some detail to give you an answer, which would take several weeks, and I could present it at a later time.
So maybe at second reading or something, you could present whether it is phantom or not.
If so requested.
And then one more. Were both or all three parties or stakeholders, did they all have extensive consultation in this?
Sorry, they do today.
Okay, but prior to this, the Cowleys obviously had a chance to have consultation. I'm just wondering if everyone did.
Other than the hard copy that was mailed, there was no consult.
Through the chair, the planning department walked the Cowley property with the landowners, and we held a video meeting with a representative of Star 6 Ranch before first reading and explained what the concept was. And they responded to us by email and with a couple of letters. Yes.
Thank you.
Any further questions? I do have one further question, and Councillor Tusa touched on it. But I was, if we go back to that slide with the orange box, where you were talking about section B, and how you went back in your records and you couldn't find anybody that, or any any applications referring to that. I don't understand how that's possible if there are, like you said, these brand new yurts on the Star Six land that are within this. Like, would they not have applied for that minimum relaxation, or how would that have worked if you didn't see any applications for this?
Through the chair, to clarify, we did not see in the documentation for 2021 a specific referral to section 26.5.2B to support the variance. It stands to reason that the MPC considered this passage when they allowed for the yurts. I was, in my intent in my statement earlier, was more thinking about the lead up to the appeal in 2019-2020, that we didn't see use of this section when we were dealing with something more substantive like a single family dwelling. Apologize for any
Okay, I just wanted to make sure everything that has been done has followed, because that allows for the 5-meter relaxation. Is that?
I may, through the chair, since the subdivision appeal board has ruled on their distance, the planning department can no longer enact this passage.
Okay. Any other questions? Okay, thank you. We may have more at the end here. All right, let me make sure I'm using the right form. Okay, I will now go to the members of public. So again, we will have an opportunity for those speaking in favor, in a neutral position, and oppose. So please raise your hand if you wish to speak in favor. In doing so, I will call you up, and when you come to the microphone, please state your name for the record. We will call you to the microphone one at a time. Just a reminder that you'll have 5 minutes to speak unless you're speaking on behalf of a group or petition, in which you can speak for 10 minutes. And just to make it clear, please let us know if you are speaking on behalf of yourself or a group. Are there any of those wishing to speak in favor? Okay, I will let you guys figure out who would like to go first.
Good evening, Gloria Cowley. I'm speaking on behalf of my family, Cowley Outfitters Limited, and our use of Rafter 6. We are in favor of the setback. To give you a little history, when the area structure plan was being developed back in 2002 to 2006, it was always our intention to have a setback similar to this 5 meters. The 30 meter and 40 meter was put in by the MD Planning Commission at the time. Well, I believe, if I can use a name, Greg Birch at the time. So we did not want this, but through the consultants and through the Planning Commission here in the MD, that's how it came to be, that it's not what we required or requested, just so you know. Also, a little history is back in 2010, I believe, we applied for a water treatment facility on the 3-acre parcel, and there was approval of that development permit, and the setback was 1.5 meter approval. It was actually, let's see if I remember correctly, I have the documents in my emails as well. But I think it was 2013 where the approval actually came through. But I think it was a 2010 or 2011 application, because we were working on the water treatment system, and it was recommended to us at the time in 2011 that we had to prepare for the 100-year flood. So that's when a well system, a new well system was created. And in order to do that, we needed approval for a water treatment plant, which would have provided water to all 3 parcels, treated water to all 3 parcels. So of course that did not happen. It did not go through as of 2013. And of course 2013 was the major flood, and one of the water wells, the original water well that was put in by Alvin Gwynn during his time, that's the one that washed down the river. So I remember turning the power off and watching the water come up and took it out. So, anyway, the 5-meter setback. When we originally applied, my daughter, Alvin Gwynn, I'll go back a little further. Alvin Gwynn did have a mobile home on that 3 acres. When my daughter and her husband, her new husband, went to renovate that existing one, it was full of black mold. So we looked at replacing that because, of course, they couldn't live in that. So that's where we brought in a small, it's actually an oil field trailer, so it's under 300 square feet. So with the expansion of their family, it was natural to have a little bit of a bigger facility. Now it's also in the bylaws or whatever that I think on our permit for the dwelling that we would have to build, like this was a temporary, the factory built unit was temporary until we could actually build. So where the small factory built dwelling is now, it's along that very narrow strip. And I would say when we originally applied for that, that 5 meters should have applied at that time. But I'm not sure, we were not happy with that, how it went to the SDAB, because at the time it should have had the 5-meter approval setback. So for us to build on that very narrow strip with an actual building, we have to actually move that small dwelling. And so that's why a slightly larger one is there, so that they can raise their family, continue to work, continue to live. And I'd also like to say that they are the only residents out of the 3 parcels that are actually living there full time. So if you have any questions, I'm happy to fill in any answers.
Thank you very much. Are there any questions? Go ahead, Councilor Alford.
I'm going to start with, I want you to know that I'm pro business in our MD. I'm pro like responsible development. I'm not, it seems like I'm asking lots of questions against, but I'm trying to get a whole picture here. But so the first dwelling that was there that you have the SDAB hearing for that's the oil field
That's right.
structure?
Yep, and it's just under 300 square feet.
Right. And so now you got that permit, and that SDAB was a temporary, was there a timeline on that you had to build a permanent structure?
By 2025.
2025? Okay. And then, so now, when you put in the new structure, did you remove the first structure, or is it still on scene?
No, we can't move it until, they're still living there. So until they can move into there, that one is on wheels. The oil field trailer is on wheels. It's ready to move whenever they can have their child join them in their house.
And so is the larger structure that has been brought in without a permit, is that being used right now?
No.
It's not?
No.
Okay.
And it's approximately 600 square feet.
600 square feet. And then when you got your original development permit, do you have a set of plans in that to build the permanent structure? Like, is that a part of that development permit, or was the development permit a temporary development permit for a temporary structure, or did you apply for it all at once?
No, we did not apply yet for a building because, as you know, we were just getting back on our feet after the moving off the property in 2014. So we have been just getting our resources back and increasing our family and our work. We're continuing to work, and we just want to build a life. We have a right to live and to work, and that's all we're asking for. Without interference, without prejudice, without being under the microscope, you know, that everything we do may be of issue. So the 5 meters would definitely improve our quality of life and our use of that very small property. And I would think that it would be an advantage to the McTaggart family as well to give them over 6 hectares of land that they can use without uh, without worrying about it and going through the planning commission. They've already activated the 5 meter setback with their yurts. And I think when we applied for our factory built dwelling, that should have been, that 5 meters should have been approved at that time or activated, not sending us to the SDAB and causing us to go through the court system in order to get a slightly larger trailer for a young growing family to live in. So I'm standing up for our future generation and our right to work and our right to live there on freehold land.
Go ahead.
Is this mobile home that's moving on, is that the new permanent structure, or is a stick-built or log structure intended to be built after, and then that one turns to temporary?
Right. The location where the 300 square foot oil field trailer is right now, that is where we believe the build site should be. So there's very few opportunities to build within that 30-meter setback. So if we're going to build a house, we have to clear that build site. So this new trailer would be moved to a site that clears that open so that we could get towards building and planning a proper home.
Would that mobile home then be removed afterwards?
Absolutely.
I do have one question, and I guess it's clarity. And I didn't realize, and so it sounds like the current 300 square foot home or factory built dwelling is where you would hope to build a future home.
Correct.
Okay. So I don't know much about construction, but I understand that putting the 600 square foot factory built dwelling on the exact same site where you hope to build a dwelling makes it hard to build the dwelling in the meantime.
Absolutely. Very
Okay.
difficult, yeah. And still, they need to live somewhere because they're working in the area.
Okay. And would you think that there would be anywhere else on your land within, I guess, within the orange line and the aqua line where you could put this other 600, the newer, bigger 600-foot factory built dwelling?
No, not really, because it's based on where the current septic is that has been approved and the
Okay.
water, the well, and the treatment or the water facility that comes up through there. So the newer one, the 600 square foot, it's not a new one, it's an older one. So the 600 square foot one rather than coming this way along the river, it comes this way, which allows, when we move this one, the small 300 square foot one off, we just pull it off, and that opens that site where we would like to apply for a building.
So if this variance of 5 meters were to proceed, and you were gonna build where your current 300 square foot trailer is, do you foresee your future building sitting within this 5 meter setback, or would it still be within this 19-meter setback?
Well, I guess that has to be worked out based on the topography and where the slope is. So that all has to be worked out, and that's going to take a little time. You know, we believe it's quite stable. It's on a shale bed, but we're going to have to do some
Okay,
studies on that.
thank you. Okay.
I would like to just add one more thing, just to clarify that undeveloped road allowance. There is a cliff on both sides of that road allowance. So Ms. McTaggart has access to the road allowance through her property and down to the river. And for us, our access is actually on our property. So if you go to the north of that undeveloped road allowance, there is actually a cliff, and I don't know where that road would go because it's floodplain below. And there's a lot of sand down there after the flood of 2013. We could see very actively where the river moved and how it even changed, you know, on the reserve. It changed the topography dramatically. And also we lost some of our land off the corner.
All right, thank you very much. Is there anybody else that would like to speak in favor? Yeah, thank you very much.
Hi, good evening, everybody. Thank you so much for being here super late on this really exciting matter and exciting Tuesday evening. So my name is Kateri Cowley. I live and reside at the Rafter 6, as we're discussing on the top parcel there, the 3 acres. And yes, as you can see, our family has grown. And a 300 square foot house is very tight for 2 people, but when you add a toddler, it gets very small. And so, you know, that was the plan originally, is that we were going to have that 300 square foot house until we were ready to build. But most people's closets are bigger than our house. So I don't think that asking for a little bit bigger house is a lot to ask for. The 5 meter setback, you know, I don't see how it really does affect anybody, because as you can see, it doesn't actually touch anybody else's property. We share a corner, which doesn't actually overlap anywhere. I believe that this is mutually beneficial for both parties. I'm sure we'll hear some opposition and otherwise. But yeah, I think that, you know, the topography of our tiny little property, there's cliff, there's floodplains, there's trees, which we don't like to remove. We want to keep as much as we can, and the history of it as well. We really do want to honor that. And we also want to honor our neighbor. And, you know, like when there was the application, we were made aware for the MPC, or not for the MPC, for the yurts that were going to be 5 meters on the side of our property line, so on the north side, like closest to our property line. We didn't oppose it because we want to have a mutually beneficial relationship with our neighbor. And you know, like some things have happened in the last few years, And yeah, there's lots of energies and feelings about it, but we're ready to move on, and we want to move on in a positive way and just peacefully enjoy our property and working there. And yeah, I think my mom said it really well too, and we just want to honor the future generations that come through there. And yeah, and I meant to, I didn't mean to, I know that there are other residents that are staying on the property, but we're permanent residents where our address is on a license plate or our driver's license. I don't know if that's your driver's license. It is? So you are a permanent, yeah, so okay. So I just wanted to clarify that because I didn't know. But anyways, yes, we are living there and just a small family, tiny little parcel, and 30-meter setback really restricts us to like a tiny little sliver of land, which is not really that usable. And besides, that's the only part of land that we actually want to develop in the future. So yeah, I think that's all I have to say. But yes, I am very much in approval. I really hope that this does go through because I really want to live in a house that I don't have to be on top. And a double bed is very, very small. Like, and there's no room for a crib. Like, it's really wild. So, I mean, she's a very good girl, but yeah, it's still hard. So.
Thank you. Go ahead, Councilor Juza.
Some of these questions might sound a little bit silly, but if we take the property line and give you the 5-meter setback on the top, the bottom, and the left, just those are the ones I'm concerned about. Would that restrict wildlife in any way?
No, not really. The reserve is on the other side of us, and we love wildlife. We welcome wildlife. So,
Are there any houses on the left side of the property? Like
on the
any
left?
houses? Are there
Left
any
side.
houses outside of your property on the left-hand side?
Oh, those are cabin leases. So they're existing cabin leases.
If I look at your property line, just the property line, Peter, on the left there, are there any houses within 30 meters on the left?
No.
There's no development. So you wouldn't interfere with anybody else's property or use?
No, there's no way you can't even see that area from any other property, from the neighboring leases, from the Star Six Ranch, from the only one that can see us is on the reserve. So, and I just have to say, I was really uncomfortable to hear that there was drone footage right directly above me. That feels very uncomfortable, and I feel like we're being spied on, and that's not nice.
I think that's it for my questions. Thank you.
So do you own or lease other lands to run the Rafter 6 resort?
Yes, we do.
Is that neighboring you, or do you?
It is in a sense. So it is actually it's the original leases that we are still operating from.
And those are crown leases?
Go ahead.
Would you be able to have a temporary, could you move your trailer onto that while you built your house?
No.
Doesn't,
No.
no permits are allowed, that doesn't allow that?
Well, there's no water, there's no power on our leases.
Okay.
The location that it's on is like basically the only place it can be in the entire property.
Oh, okay. Thank you.
We'll try.
I can try my best.
Okay, you had pointed out the three cabins that are farther left. Yes. Who runs those? What are those about? Do you know any? Do you have any information on those places?
Those are separate leases that have nothing to do with us. They only have so many days that they're allowed to stay. They're not permanent. It's I'm not sure exactly their agreement, but there are 3 different families, I believe.
And so would they hold their agreement with the province?
That's a good question.
Okay.
Yeah, I believe they would, but I'm only because it's Bow Valley Provincial Park. I think that was one of those things that was grandfathered in a long time ago. But yeah, I'm not certain though. Are there any other questions?
Okay, thanks, you guys. Thanks for all showing up.
Thank you. Are there any more people present who wish to speak in favor? Okay. If there are no more people wishing to speak in favor, I will call up anyone that would like to speak with a neutral position. Please raise your hand. Okay, seeing none. Oh, sorry. Oh, go ahead. Thank you.
Hello, my name is Robert Clausen. I am not an owner of either property. I just had a question for clarification, and I wasn't sure if anybody else was going to ask. So, the case that the previous presenter made seemed reasonable in some ways, and so my only question was, did I understand correctly that there's an existing provision where the Municipal Planning Commission or MPC or something like that can approve a variance for the 5-meter thing, and that might be a very efficient way to deal with their temporary accommodation needs while they're figuring out what they want to build? Am I understanding that correct?
Mr. Schultz, do you want to respond?
Thank you, through the chair. Short answer is no. Because the Subdivision Appeal Board has ruled on a certain distance, it is now outside the power of the Municipal Planning Commission and the Planning Department to enact 26.5.2b for the 5 meters.
So the Municipal Planning Commission can no longer use that clause, is what you're saying?
That's correct.
Because a higher authority than the Municipal Planning Commission has said 19.
That is correct. There's a hierarchy. The Municipal Planning Commission is delegated by council, and the Subdivision Appeal Board is given quasi-judicial rights under the Municipal Governments Act. So once they've ruled, the Planning Department has to go by that setback.
Okay, so that does help to clear that up. Thanks. So then the follow-up to that, now that I understand that a bit better, is so this 5-meter setback that's being discussed tonight does not change this 19-meter that some higher authority has already determined. Whatever gets decided here tonight doesn't change that 19 meters because that's by some sort of superseding authority, correct?
Through the chair, well, the decision is not being made tonight. This is just the public hearing. Land use bylaw amendments require a first reading, then a public hearing, and then a second reading, and then a third reading. Their land use bylaw amendments are not subject to the SDAB, and council can, the authority of council to amend the bylaw is, would render the SDAB decision moot if they chose to amend the setback to a distance less than 19 meters.
Okay, that answers the question. Thank you.
Thank you very much. Are there any questions that has provoked from council? Go ahead.
If there isn't a 5 meter, if this wasn't changed, can the Cowleys build their a permanent structure within the 19 meters? Or is the 19 meter SDA hearing just temporary till 2025?
The setback stated by the SDAB is permanent.
So they could build within 19 meters then? No.
19 meters or greater.
So it's not 30 meters on that side then?
No, it's 19 meters
It's
on that
19
side.
meters. So it actually, okay. So they've gained some, and as long as they built their permanent structure within the 19 meters, they would, essentially they've gained some. We're not dealing with 30 meters anymore. We're dealing with 19 for them.
On that side of the property, yes.
And that's from the front yard setback.
Which is the west side, yes.
Okay. Thank you.
I do have one more question that conversation provoked, and I'm curious as to, I guess, to understand if that 5 meter clause B was why it wasn't used. I guess when it was, I don't know. I guess, is there a reason why that wasn't used?
Through the chair, I was not able to find information in the records to directly answer that question. Based on the circumstances, if I had been director of planning in 2019, and considering the history of concerns between the parties, I probably would have addressed it directly and why I did or did not recommend it. But when you read the wording, relaxation in terms of topographic features, one immediately thinks of things like floodways and steep slopes, as that is what that passage was written for.
Mm-hmm.
So I would have felt a need to address that directly to the MPC as to why or why not the planner in charge at the time made their recommendation, because it didn't.
I understand. You would have made a different decision or different.
I would have seriously considered a different approach.
Okay. Thank you. Are there any other questions? Yeah. Go ahead, Councillor Smith.
As we've heard so far, that there is the 300 square foot trailer that's there now. They moved in the 600 square foot and got the stop order on that. Maybe I've got this wrong. So they're moving in the 600 so they can get rid of the 300 and build as a part of what was already approved. They have to build by 2025, according to that, in the 19 meter setback. Is there some provision that can be granted if that 600-foot trailer is only temporary and is only a temporary means? Can it be given discretionary use until the permanent structure is built to be over and above that 19 meter setback that doesn't go against the SDAB ruling?
Through the chair, no. STAB has ruled 19 meters. The planning department will enforce 19 meters until instructed elsewise, either by council or by council.
You said you walked the site. Is there a reasonable building site with the 19 meter setback? And I understand that maybe not with the trailer and a house being built, but if the trailer wasn't in the way, could they still build a house within that 19-meter setback? Is there a reasonable spot?
Through the chair, it's pushing my area of expertise because my expertise is land use planning, not on master planning, which it implies a functional knowledge of utilities and septic systems, which I do not have. I'm calling up people on the Google Maps and Yellow Pages if I need a septic field. I'm not designing it myself, is what I'm saying. To make it fit, the new mobile home would basically have to be squished right next to the existing one, side by side. But I'm not sure about the print of the septic field offhand, and I didn't take a master planning perspective. I was taking a land use bylaw perspective when I was there. The only way I could see it work, just based on pacing out the site and seeing the dimensioning, as I said, it would be the new building would have to, the new trailer would have, the 600-foot trailer would have to be squished up right next to the 300-foot trailer. And the construction site, I don't know where the septic field is on the site, so I can't answer that as fully as you'd like.
But if the trailers were moved within 5 meters out of the way, and then they built within the 19 meters with, let's say the trailers are right up against the lot line until the place was built, is there enough of a flat spot to build a house? Not with the trailers, take the trailers completely out of it.
Through the chair, yes.
Thank you.
Are there any other questions? Thank you. Is there anybody else that would like to speak in a neutral position? Go ahead, sir. Just a reminder to please state your name.
Name is Terry Willis. I'm just wondering, the other land manager is the provincial park, and what's their thoughts on this change?
I guess we can present that question to administration, but has there been a correspondence with the land manager neighboring I guess it's not a municipality, but with the Crown?
Through the chair, I apologize for my brief absence. It's something I had to deal with very quickly. For Government of Alberta, we would do external referrals, and that process would be complete before a second reading. The Government of Alberta did phone me directly on Friday, and I explained the layout, and they didn't say yes or no, which you wouldn't expect, but their concerns would be limited to whether it would affect park operations or not.
Thank you very much.
Yeah, I think that would be important to get their feedback, and it's probably more than park operations. It could be like the natural environment of the park, which you should definitely look at their feedback.
Yeah, I believe they would be part of the correspondence that would be going out to neighboring properties. Is that correct?
They will be approached through external referrals.
Thank you, that's all.
Thank you. Thank you, Derry. Is there anybody else that has a neutral? Okay, go ahead, please. And I guess just for point of order, I probably should have pointed it out the first time, but questions should be directed to us, and then we can ask administration for the answers, so.
My name is Alex Taylor, and I'm a Harvey Heights resident. And it's my first council meeting, so it's been very instructive to see how things work. I'm not a long-term Harvey Heights resident, been living there now for 3 years. But it's really interesting to see the process of what's been going on here. And I am familiar with the Star 6 and occasionally rent them the space for business, which is a drone business. And on the point of the concern of the Cowleys about feeling spied on, I can understand that. But we instruct all our people or students taking courses to remain off their property specifically for those reasons. And also the Transport Canada law, they regulate the airspace, and there are no laws that say you can't fly over property. You can say that you're not allowed to operate from, take off and land from a specific property, but you're not restricted from flying over as long as you're at a reasonable height. And then the privacy laws kick in otherwise. And I can go along that, but that's not what I'm here to comment on. In Harvey Heights, as I'm sure you're all well aware of, there's lots of concern from the residential residents of Harvey Heights about the developments on the Harvey Heights Road there, and that's been expressed in previous meetings and topics that have come up. And what I think I can speak for many of my neighbors for is if there are any mechanisms by which the Cowleys can be permitted to build their house without having to change the law, that would probably be the preferred mechanism. If they can be given temporary setback to move their trailers, et cetera, but it'd be possibly a negative precedent being set that bylaw. I know that these bylaws only apply to this zone, but negative precedent that laws are being changed.
Sorry, I would just need to get confirmation from council.
Yeah.
Are we okay for 1 or 2 more minutes?
Yeah, I'll make it quick.
Okay, thank you.
Just that precedents could be set of incrementally changing laws that result in more development, and we go a generation or 2 down the line, and we have a valley that's clogged with developments and people and having cumulative environmental impacts, et cetera. So just express that concern from some Harvey Heights residents. Thank you.
Thank you very much. Are there any questions, Mr. Taylor? Councilor Tusa? No? Thank you. Is there anybody else that wishes to speak with a neutral perspective? Go ahead.
The mic's still on. Hi, my name is Bill Hunt. I'm a resident of Harvey Heights as well. I would just like to, I'm not opposed to the 5-meter changes in other parts of that, but I would ask you to exercise caution anywhere you're abutting a riparian area, especially something as significant as the Kananaskis River. I don't feel that 30-meter buffer should be, the setback should be infringed on in any way, shape, or form. You can see some areas where that 30 meters exceeds the floodplain area, and I think we've spent a lot of tax money in this part of the valley poorly mitigating and managing flood risk. And so, I hate to see anybody building or encroaching any closer than the minimum 30. As a paddler and a angler, I really hate to see anything happening closer than 30 meters to the river. It affects my experience. It affects my ability to move up and down the river, which is my right as a Canadian. Those rivers belong to all of us. And finally, you should check under the SARA designations, bull trout are a threatened species. The critical habitat setback for bull trout is 30 meters, ironically. Seems to be a theme here. And that area right now isn't, as far as I understand, is not designated as critical habitat, but that's a dynamic process, and so that'll change over time, and at any point that could become critical habitat, depending on populations of bull trout in there. So again, preserving that 30 meters on the riparian side would be wise for everybody, I think. That's all I have to say.
Thank you
Any
very
questions?
much. Go ahead, Councillor Chusa.
Based on what you just explained to me, then would it make sense that the 5 meter, that they be allowed to move the line to the 5 meter left-hand side of the property rather than the current 19 meters that it's at right
That's
now?
why I jumped in for the neutral crowd. I'll let other people figure that out away from the river. My concern is, as somebody who spent their lifetime protecting rivers, we shouldn't be infringing on a 30-meter buffer in a riparian area for the reasons I stated.
Right, so
Yeah.
that would actually move any development further away from the river.
That's right. And in this case, it may be largely semantics based on the turquoise line, which I'm not sure how rigid or how flexible that is, but rivers move. These are all gravel bed river systems, and they need to move to stay healthy. If we constrain these rivers, and obviously this is a dam system, but even then TransAlta occasionally has to let some water spill, as we saw in 2013, to spectacular effect on the Cascade Creek. These rivers, that's what keeps them healthy, that's what keeps them vibrant. It's that sorting of gravels and the cleaning of silt that allows up to 70 or 80% of a river can actually be under the channel, the hyporheic flow that happens outside of the wetted area. So we shouldn't be building structures, and especially if you get into talking about septic fields or structures, you're just asking for trouble.
Is the blue line, does that supersede what we would be doing if we did the 5 meter? Like, is that an Alberta government 30 meters to the creek, river?
Through the chair, the floodway and slope restrictions are in the MD Bighorn Land Use Bylaw under general provisions, and they sit on top of development setbacks like the ones we're talking about. So if the development officer is looking at a development which may be on a steep slope or may be near a river within a certain distance, then they will usually require a DIA, a development impact assessment, which would look specifically at getting the exact geomorphological boundary of the floodway and or the exact limitations of the maximum slope requirements, or both, and come to a recommendation from there on how far the setback could be from those features.
So we could do a way more custom line along that turquoise, and then not have that 5 meter setback that just naturally follows. Like, I know, how can I say this? It's easy to just say 5 meters all the way around the property. Is there a way that we could do it so that that line was set on that edge, not within 5 meters, but 30 meters to the river? Or
Through the chair, absolutely no problem. We could just put it on the map saying this is our setback from the eastern property line, and you can set whatever number you like. Right now it's 30. We could have 30 on that side and 25 on that side, whatever number you want, and just put the other property lines at 5 or some other number.
could we set a moving target as the river changed?
Through the chair, it sort of already is a moving target. It's structured that way, which is why it says it has a qualitative definition of floodway to allow for the professional geomorphologist to come in and define that line as it exists at the time of application, and other outstanding features that need to be considered.
Thank you.
actually had a similar question. So it is good to understand that we could potentially have one setback on maybe the river side and then a different setback on the opposing side of the property line. But okay, thank you. Any other questions? Yeah, go ahead.
So in that, does it have to be within the whole Rafter 6 Tourist and Recreation District, or can it be in just one portion of that?
Through the chair, you want to be consistent in your definition of the setbacks. If you're using Riverside as your baseline, I'd recommend saying X distance from Riverside property line across all properties that in that zone. I wouldn't break it down. It's not best practice to break down property by property regulations, except in extremely unusual circumstances, which I would argue the Kananaskis River is the Kananaskis River.
All right, thank you.
You had said earlier that the question had been raised. Uh-oh, I might be mixing up my public hearings. There was, yep, sorry, it's getting late. Council had asked the question, no, the public had asked the question about the impact on taxes and tax assessment. When you bring that forward to council, could you also take into consideration that and the impact it would have by using the river flow line rather than 30-meter or 5-meter setback? That might be too big of an ask. I'll let you.
Yeah, sorry, through the chair, we'll just check. I'll just ask the finance department for clarification on their tax assessment algorithms, whether it considers developable area, and if the answer is yes, then you'll have both answers.
All right, is there any more members of the public that wish to speak with a neutral position? All right, seeing none, I will now call for those speaking in opposition to the proposed bylaw. Please raise your hand and state your name for the record. We will call you up to the microphone one at a time. Just a reminder that you have 5 minutes to speak unless you're speaking on behalf of a group or a petition, in which you can speak for 10 minutes. And just so everybody knows, I will call a bio break at 9:30. So if whoever would like to speak next, please raise your hand. Oh, go ahead.
Hello again, it's William Cunningham, longtime Bow Valley resident, representing my peers, who are mostly still young. How many of you have had the opportunity to fly over these areas in a helicopter in the last few years? 5 to 10. Because of my business, I've had the opportunity to go up with clients maybe once every couple of months, usually from Alpine. And there's one thing that strikes me every time, and this goes for Canmore and Banff and the whole area west of Calgary, and that is the amount of stuff going on the land and how close this stuff is to other stuff. And in the last 7 years, I would say, it's gotten worse. And the perspective that I see when I go over is, holy cow, there is not a lot of land here. And it is getting filled. And this troubles me. So that's one. And the other question, and this is, again, why I'm here, and I promise not to come to too many of these in the future, but something that I've been engaged with in Banff quite often, especially, is there are two themes. One is density of development, and what does that development look like, and how does it function, and how does it work with our environment? And because I'm pro-development for the most part, I think these are hard questions sometimes to ask ourselves. And the other theme is the incremental development in small increments over many years. And having lived in Banff for 20 years, I've seen those small increments, one tiny decision after another. And it has changed the experience and the density of what's going on, and not always for the better. So this leads me to ask, what does the business plan look like for the Star Six Ranch and the Cowleys in the future? And how does that business plan play into how the land is being used and whom it is impacting, both in parks, animals? What are the constituents? Parks, animals, environment, business, people, other owners? What does that look like as a whole? And what does that look like over the next 50 years, maybe even 100? And I don't, through this session again, wanting to really clearly understand, the process you guys have to go through is really something. Holy. And 30 meters, 5 meters, 40 meters, whatever. For the most part, this isn't so huge for me or my peer group, I think. It is the question of what is the development taking place on that land and the ratio of that land. What does the density of that look like? And what does that look like over the next 50 years? And one thing that pops out for me is the size of a ranch that is, 100 acres, and then the size of a property that's operating a business, which is 2 acres or 3 acres. And what do those business plans look like based on that ratio of land? And I wasn't able to gain a clear idea of what that looks like from this session. And I would want to go back to my peer group and say, this is what the next 25 to 50 years looks like for that ratio of land in this area that's obviously important and protected. And I would want everybody in my neighborhood to fly in a helicopter, and despite the fuel usage, to see that perspective. We always hear from astronauts that go up and they go, oh my gosh, this Earth is nothing. We've got nothing here. It's so tiny. And that's the perspective I get every time, and it frightens me. That's all. Good night.
Thank you very much.
Thank you. Yeah, thank you.
I think
Your
we
jobs are
all-
really something.
I think we all wish we could fly over most of the MD in a helicopter.
We can make it happen. I will find a way. You want to go on a helicopter ride tomorrow? I will find a way. So I don't know how to follow up on these decisions in the future as they unfold, but I do know there are many groups of people in southern Alberta who care about these tiny decisions, and they realize that the increments of these have a big play. And I'm not opposed to what's going on, even though I'm speaking in the opposition side right now. I'm only opposed unless convinced otherwise, and it makes sense. And I'm not there yet. Okay, thank you.
Mr. Schultz?
So that was only 3 minutes?
Go ahead, Mr. Schultz.
Through the chair, I thought it'd be worth a couple minutes to reiterate the responses to the gentleman's questions, just so for clarity. The 2018 land use bylaw density limitations in the RSTR district are as follows: 1 single detached dwelling per parcel, so maximum of 3 across this district. Recreational uses have a maximum density of use of an anticipated 1.5 persons per acre, which translates to 3.7 persons per hectare of development site, or as approved within an area structure plan. These are fairly low numbers, and my guess is that the properties are near their max or at their max at the present time. As was alluded earlier, the Rafter 6, there's a number of recreational leases within Bow Valley Provincial Park, and the majority of the Rafter 6 tourism operations occur within those leases, and they would be subject to the management of Alberta Parks through their park planning system. And I would have to defer to the Star 6. I believe they have a lease, but I can't picture the map in my head, so I can't answer that. But I think that answers the concerns raised by the individual who just spoke.
Are there any questions? Thank you. Is there anyone else that wishes to speak in opposition to the proposed bylaw? Go ahead.
My name is Fiona McTaggart, and I represent the Star 6 Ranch. Well, I just lost everything I was taking notes on, so I'm going to have to be spontaneous. There are significant topographical challenges with the 2.9 acres, for sure. And if I was in the position of the owners of the 2.9 acres, I would be seeking a relaxation on the side yard setback, for sure. And I believe that a relaxation on the side yard setback for the 2.9 acres, which is owned by the Cowley Outfitters, should be granted, absolutely. And I got a little confused because I think there is a disposition that was read by you, Peter, at the December 13th council meeting in 2022, and you read it verbatim, where a provision exists for this council to relax the side yard setback on a case-by-case basis.
Through the chair, I
go ahead.
can't remember everything I said back in December, but if I referred to this statement, I would have referred to it in the context of the SDAB statement. So if I wasn't clear enough, I apologize, and that's part of the reason I try to speak very slowly and restate myself. But that has been my understanding for the whole time.
That there, so luckily there is a YouTube recording of that December 13th meeting, and I did watch it quite carefully before coming here. And I also wrote a letter, and I stated that this provision exists for this council, for the MD of Bighorn, to relax the side yard setback on a case-by-case basis. And I would like to point out that the Star 6 Ranch took advantage of this provision when we installed one of our 2 yurts. And we did it legally. We went through council and we stated why our reasons existed to relax the side yard setback. And we were granted a legal setback in order to put our yurt up as close to the property line as we did. This provision exists. So really, I should stop talking because the 2.9 acres is topographically challenged, and you have the ability to relax the side yard setback for that property when they come to you with their plans for a permanent dwelling, which of course, as every Canadian should have, they have the right to have and enjoy their life in freedom and peace. So there are a couple other sort of piecemeal um, things that I just want to address, and I'm going from the top of my head. The Star 6 Ranch does not have a lease provided to them by Alberta Environment and Parks. So I hope that clarifies. Councillor Tusa, you asked if wildlife would be disturbed, or I think, and I would just like to say that I certainly do not have any authority or education to answer that question. I don't think anybody in this room, except for maybe, I'm sorry, you one who advocated for the river, Bill, you might, but I think that that is a question that should be answered by someone who has dedicated their education to what wildlife need and don't need. So I just wanted to touch on that as well. The Cowleys, I want to touch on the access easement agreement. There is an access easement agreement that runs right through the Star 6 Ranch, and it provides access for the Cowleys to access their 2.9 acres, as can be seen. And this is a good time for me to say I object to the use of the word phantom, because that road allowance that is delineated by the white lines that run from the top north to the bottom south is actually a government road allowance. It is, it's not, there's nothing phantom about it at all. And actually you can see that when the Cowleys use the access easement agreement that runs through the Star 6 Ranch, they actually use that driveway. I think that map is actually a little bit off because it goes right beside their property and gives them access into their property. So there's nothing phantom about this government road allowance. It exists and it's real. I also heard the word cliffs used. I don't know, when someone says cliff, we all have a different thing that pops up in our imagination. But when I hear someone say a cliff, I think of the face of Yamnuska, like literally a cliff. At the northern portion of the Cowley Outfitters 2.9 acres, there is a nice gradual pathway and descent down to the river. I know that because I have used that government road allowance to ride my horses and to access the pathway system that runs beside the river. And it is very accessible. You can walk it, you can ride it. I'm sure one day there will be little children biking it. There are no cliffs. I also want to touch on the access easement agreement. So when I purchased the Rafter 6, the Rafter 6 Ranch, which became the Star 6 Ranch, I walked into this very carefully and with my eyes wide open, because I was acutely aware, as I still am, that I can go bankrupt. So I was very cognizant of this access easement agreement, which I had to honor and want to honor. It was part of the purchase, and I bought it. I think another point of clarification is the Cowleys operate their business, and they talked about it quite openly, to the northwest of the Star 6 Ranch. Thanks, Peter. No, further up. Yeah, right there. That's where you can see where their corrals and horses have eroded the lands. Right there. That is a lease land that they lease from Alberta Environment and Parks, and upon that lease, they run their business. The access easement that gives them access over the Star 6 Ranch lands to their property is for residential purposes only. So I struggle every spring and every fall because a lot of traffic goes back and forth and over my lands in support of the business that they have every right to run. And indeed, it adds to the economy of this area. But it does not honor the access agreement that I have honored pretty much since day one. And I say pretty much because in the very beginning, there was a little bit of conflict as I tried to understand, and it had to do with the access easement being used for business purposes, not for residential purposes. But other than that, I have honored this access agreement for residential purposes since the day I purchased the Star Six Ranch. On the other hand, it is used every May over the whole summer until October for in support of the business that is run on leased lands. So I wanted to bring a little bit of clarification to that because I lost everything that I was taking notes on in my phone, and I'm sure that I am at my 10-minute limit. I would just like to state formally that I am very opposed to this relaxation on the side yard setback, especially when the provision exists for you, the council, to relax the side yard setback on a case-by-case basis once you have analyzed the arguments as to why. And that is something that the Star Six Ranch took advantage of. And the yurts that we have built on our land are legal encroachments on the side yard setback. Thank you very much for listening to the public.
Thank you very much. Are there any questions for Ms. McTaggart? Go ahead.
I believe the Director of Planning stated that the SDAB had a hearing and they limited the setback that we're talking about today to approximately 19 meters, I believe, Peter, you said. Therefore, what you're saying is that council has the option of, on a case-by-case basis, to move it to a 5 meter, but I believe Peter said that's not the case. So I will be following up with council later to maybe seek a legal opinion on that. But it sounds like council or SDAB from this would not be allowed to supersede that prior decision of 19 meters. So the 5 meters is not available to us.
Okay, well, thank you for clarifying that, Councillor Souza.
But I'd like to carry on further with another legal opinion on it. I'll be following up with council and with the administration on that.
And I think it would be worthwhile because this is actually an extenuating circumstance. It is a topographically challenged piece of deeded land that is not very big. It is 2.9 acres. And there's a family trying to live their life on that land. In this extenuating circumstance, they should be given the right to build a home and meet all the other needs, the septic, the fresh water, how many animals can be kept on the land, and it should be open and transparent, and their home should be supported by this council. It is an extenuating, unusual circumstance.
Thank you. Any further questions? Go ahead, Councillor James.
Because the road allowance has been brought in a few times, road allowances are lines that cover the land, and they are considered two-way streets. And do those two-way streets, they extend across the reserve as all the, up and down on that map, and do they also go east-west? I assume that map is pointing north-south.
Through the chair, on the bounds of the map, there's no right-of-way heading east-west, and I'm not familiar with where the road right-of-ways are outside of the bounds of the map above behind me.
And just one other clarification that Councillor James made me remember is that the Star Six Ranch does use that road allowance. As I stated in the previous public hearing, we are working hard on our collaborations and our partnerships to expose people to the outdoors. We have partnered, one of the groups we partnered was Bow Valley SUP last summer. And we were super excited, as was Brandon and the other people that he works with, to do a short run down the river to an exit point, and then you could portage back your SUPs and maybe even one day kayaks back along that government road allowance to put back into the water and try your swift water travel down the river. It's a very unique, very unusual opportunity to expose people to the importance of river travel. Water safety is just a huge opportunity. And because I was speaking about dreams and wishes, I actually really have a dream also of how do we combine the use of this river with horsemanship that goes back hundreds of years. And instead of people having to lug their SUPs or their kayaks back along that road allowance and portage them, you could actually at some point have a team or a horse drive a carriage, and then those that aren't really interested in swift water would be able to still expand their horsemanship as they drove teams to carry the SUPs and kayaks back up. The opportunities for education and participation in the wilderness and growing and learning are just endless, and we are only just beginning to tap into them. And we have a huge responsibility to the parks and a huge responsibility not to keep encroaching on the flora and fauna with whom we share this world.
Are there any further questions? I did have one more question, and Ms. McTaggart brought this up, but it sounded like you're quite supportive of trying to find a solution so that the Cowleys can build a home there in the future. Through Mr. Schultz, is there an opportunity for a temporary variance to a setback? Or, like, I'm not sure if that's a possibility, or because it sounds like there's quite a pickle right now where there's nowhere to put the 600 square foot factory built dwelling so that they can still have a place to live on the land and then still build their future home. Is there any provisions, or is that something we would need to continue to look into?
Through the chair, before this meeting, I had a verbal meeting with our senior legal counsel at Brownlee Associates in Edmonton, and we discussed the situation, and she outlined that getting out of this pickle, there were only two methods. One was to vary the land use bylaw, and the second one was for the Cowleys to put in a development permit that they knew would be rejected, and then appeal it, and that would require to go to subdivision appeal board, and then the subdivision appeal board could relook at their 19-meter setback. Our legal counsel was clear with me verbally. She did not write. I did not ask her for a written note, but she was clear with me legally that those are the only two legal options in this case.
And when you say rewrite the bylaw, that is this.
Sorry, I mean the amendment of the setback.
Okay. Yeah, you feel free to comment on that.
Well, I just seek clarification because it is the Cowley 2.9 acres is a completely separate deeded parcel from the Star 6 Ranch. So therefore, relax the side yard setback for that deeded parcel of land that is completely surrounded by parks and the river without having to change the land use bylaw for the whole, for the neighboring property. It stands on its own. It is 2.9 acres and relax the side yard setback for the 2.9 acres.
And just to be clear, you would be supportive of relaxing the setback on just the 2.9, but then not the two other parcels.
Absolutely. I believe very strongly in not encroaching anymore on our wild places. And the setbacks that exist do the job that they're supposed to do. This is an unusual circumstance, and for that 2.9 acres, absolutely, the family deserves to have a home and build it according to all the Alberta health and safety standards, and just relax the side yard setback for that 2.9 acres. But don't touch it anywhere else, because anywhere else is not an extenuating circumstance.
Right. All right. I really appreciate that clarity, because I think that provides a different perspective here for council too. Because I think as it was presented, council saw it as a benefit to all, but if for your parcels of land, if you see it as more of a benefit to not include your parcels, then that will definitely be something that council will be talking to administration about and trying to understand if there's a way to just separate those parcels, I believe. So, yeah, thank you for that.
You're welcome, and I do say it. I think you have to walk the talk. You have to walk the talk. If you say you are in favor of protecting the wild places and you no longer want to encroach on flora and fauna who share this world with us, then you must do that. And that is the first pillar upon which we stand. We are stewards of the land.
Thank you very much. Yes. Thank you. All right, is there anybody else? Oh, actually, well, maybe I'll ask the question first, and if there isn't anybody else speaking, then we can conclude this probably quickly. But if there is, we will take a quick bio break. So is there anybody else looking to speak in opposition? Anybody else speaking in opposition? Okay. Do you mind if we take a quick 5-minute break then? Okay, perfect.
Is the mic on?
Yeah.
Is the mic on?
You still need to
Hello,
tell us your name.
it's Kevin Collison, Fiona's husband, Star 6 Ranch. Hello, everyone. Sorry it's taking so long, so late. Fiona and I have never been opposed to anything that's been happening, except we do not appreciate the lack of permits in place for all that's been going on. There was not a single permit applied for, and I would like to thank William Cunningham for showing up tonight, because it was brought to our attention that there was another trailer on the property when he flew over with a helicopter, and he sent me a video, and that's how we became aware that there was something improperly placed within the 2.9 acres. So Fiona and I do not oppose the relaxations. What we do oppose is the lack of due process. And there has been a history of lack of due process from Cowley Outfitters for quite some time.
Thank you.
Thank you. Thanks, everyone.
Okay. Are there any other people wishing to speak in opposition? All right, thank you. I will now ask council if there's any final questions of administration. I think we've been doing a good job of asking administration as we've gone. There are none? None? No? Okay. Is there anything that administration would like to clarify or correct from today's hearing? Go ahead.
Through the chair, there was a statement made that at the presentation for first reading, that I made a statement to the effect that section 26.5.2B, allowing the variance to 5 meters, could be enacted in the current circumstance. I didn't have time to think about that, and council would have been present, so I did not say that. I did not intend to say that. When I mentioned that passage, it was in the context of why did we pick 5 meters? Trying to give an example of why would we look at 5 meters for an appropriate amended setback for this RSTR district, and it was right here. So I mentioned this one says 5 meters, so it might be, so that's some, as a backup. That was the context in the first reading. I have time to remember that now. So because the statement was made publicly that I said something inaccurate to council on first reading, I felt the need to state what happened to my recollection.
Thank you. Is there anything else administration would like to clarify or correct from today? All right, thank you. Okay, we have now come to the end of this public hearing. I remind all present that council will not accept any further written or oral submissions on this matter once the hearing is closed. Councilors, is there any reason I cannot close this meeting? All right, seeing none, I now declare the hearing closed. Thank you all very much for coming.